Discussions in the following show should not be construed as specific recommendations or investment advice. Always consult with your investment professional before making important investment decisions. Bill Gregat is a registered principal. Securities and investment advisory services are offered through NPC of America, member FINRA SIPC, a registered investment advisor. Anchor Certified Planners Group, Inc. and NPCOA are separate and unrelated companies. Time now for the Anchor Money Line, brought to you by Anchor Certified Planners Group, Incorporated, with your host, Bill Gregat, Certified Financial Planner. To call the program, dial 239-0033.
Good morning and welcome to the Anchor Money Line. My name is Lori Taylor and I am one of the investment advisors at Anchor Certified Financial Planners Group. Before we launch into our show today, and we have a terrific show today, I just want to tell you about an event that is occurring this evening, Wednesday, August the 17th, tonight at the Greektown Taverna. It's at 150 North Nova Road, a restaurant there in Ormond Beach. This event is hosted by the Business League Network, and it's a town hall meeting where you can meet three of the candidates who are running for Volusia County District 4. Now, these are the folks that vote on issues that concern our lifestyle here in Volusia County. The big hot topic of beach driving. They're one of those people that vote on that. So if this is matters of concern to you, and you're definitely going to be voting for one of these folks, so it's a great opportunity to meet them, see who you'll be voting for. Again, it's tonight, August 17th, Wednesday, at the Greektown Taverna, 150 North Nova Road. I sure hope to see you there. Well, last week we talked about a new website that a gentleman by the name of Julian Cantillo started called findingassistedliving.com. And as I mentioned, this is kind of a two-part series that has to deal with how do we help our parents as they age, as they make that transition maybe into deteriorating health or mental conditions. How do we find them places to live? But I promised you last week that we would talk about the legal aspects of how do we help our parents, and also how do we help ourselves as we age, as we go through this. So today I am thrilled and honored to have with us Wendy Mara. Wendy is an attorney at is it just Mara Attorney is what you call it?
Law P.A.
Very good. Here in Ormond Beach, and she's here to talk with us about some of the landmines we can avoid and what documents we really need to help us as we age. Welcome, Wendy.
Well, thank you very much for inviting me. I'm thrilled to be here, and I love talking about this topic. It's something that I do on a regular basis and with my clients. Sort of a little bit of information about me so the listeners know. I am an attorney. I practice in the areas of family law, probate, guardianship, and estate planning. And the focus of my firm is to protect individuals, their families, and their assets. So we do that in those various practice areas.
That's, like I said, I'm so thrilled you're here with us, Wendy. We had joked about estate planning, and before I got into this business, when somebody said estate planning, I thought, well, that doesn't affect me. I imagine like Downton Abbey, one of those huge English two-door estates that you had to own one of those to even care about estate planning. So let's break it down. What exactly is estate planning?
Hey, and I'm glad that we're starting there. I actually had a client call wanting a will. And I said to her, okay, let's schedule an appointment to discuss your estate plan. Oh, no, I just need a will. And then she began to explain, I don't have a lot of assets. I just have a house and some bank accounts and investments. And
I don't have an estate.
And so I guess we do need to start, what is an estate? And the legal definition of an estate are those assets that are left behind when somebody dies. So it can be a very large estate where you have millions of dollars, or for the average person, it's probably a home, some accounts, whether they be large investment accounts or bank accounts, personal property items. All of that is part of somebody's estate. So if you, as an individual, don't decide how those assets are going to be distributed, then the courts will decide. In addition to worrying about the assets And we talked about this previously. An important part of estate planning, another consideration, is how are you as an individual going to be treated when you are at the end of your life, and for whatever reason you are unable to stand up for yourself and to verbalize yourself how you would like to be treated. So when we're talking about estate planning, we talk about not only wills or trusts if you have any other purposes for having a trust, but also there are other documents that should be prepared as part of that estate plan.
I think that's so interesting, Wendy, because I kind of joked and said, let's not call it estate planning. Let's call it you're going to die planning, because we're all going to die. So if people realize I need to take care of this because I'm going to die, but then people don't want to take the responsibility for thinking about other people after they're gone. They're like, hey, I don't have to worry about it. I'm gone. But it's so interesting that you bring up, it's also covering how you will be treated while you are still alive toward the end of your life. And maybe you're not going to be incapacitated and you need somebody to step in and make healthcare decisions for you, but maybe you just can't write a check anymore. You know, how are you going to pay your bills? It's all of those things, your quality of life. So let's break it down, Wendy, and let's talk about the basic bare minimum legal documents that everyone should have.
Okay, well, I am going to start with a will, not because I think that is the most important, because it's just things.
Yeah.
But I'm going to start there because most people will call me and say, I want a will. And what a will do is make those decisions as far as who gets what, who's going to be in charge of your estate. Different states call that person a different name. In Florida, we call it a personal representative. You have some states where they're called executors. But basically, that's the person who gathers all the assets, protects those assets, and makes sure that the assets are distributed to creditors and then to whomever is listed. If there's a will, then it's by the will. If there is no will, then there are statutes, and Florida has statutes that decide how those assets are going to be distributed. One thing I did want to mention, we have a lot of individuals in Florida who come from other states. And certain areas of law are state-specific, and in particular, probate is a state-specific law. So how things are distributed in another state may or may not be the same as how they would be distributed in the state of Florida. Another issue that I've come up against is when somebody is choosing their personal representatives. One thing you need to keep in mind is if you want somebody who is not a relative to serve as your personal representative, that person must reside in the state of Florida. So you can have a relative who is outside of the state of Florida, but if this particular person you'd like to serve as personal representative is not a relative and lives outside of the state of Florida, you need to be choosing somebody else, because that one of the requirements of a personal representative is they live in the state of Florida unless they're a relative. There are some other requirements. For example, they can't be a felon. They can't have, there are certain things that, we want to make sure that somebody who's handling the estate doesn't have some sort of a criminal history.
That's really interesting because, like you said, there's a lot of people that move to Florida from different states and they feel, I'm already taken care of, I already have this will, but it may not be valid here in Florida, or again, they're going to run into problems like that. Now, since you said a will is state-specific or probate is state-specific, every will has to go to probate court, is that correct?
Not necessarily.
Okay.
If you have a husband and a wife, and a wife has passed away or a husband has passed away, and all of the assets are titled in the name of both the husband and the wife, then a probate does not need to be done, because the spouse would automatically receive everything.
Okay.
Because both of their names are titled on everything, unless there are assets that are only in the husband's name or only in the wife's name. So many times I don't see somebody for a probate until the other spouse has died, and then you have children or parents or siblings who are having to probate the estate.
I have to, since we're talking about probate, it seems like that's like a dirty word, or like part of Dante's Inferno, that someplace you definitely don't ever want to go. Like everybody is always, avoid probate, avoid probate. What exactly is it, and why is it looked at in such a way?
Well, probate is where the courts, it's a process for the estate to be administered and for assets to be distributed, making sure that creditors are paid. yes, most people are wanting to, and that's really the trend. How can we avoid probate? A couple reasons why people want to avoid probate. One is there is a cost associated with probate. The Florida statute sets out what a reasonable attorney's fee is for a probate, and if you were to, it goes in stages, but overall, if you were to sort of come up with an average, it's about 3% of the estate.
Wow.
It gets less as the assets are larger and you go over $1 million, but most people who have those kind of assets have a trust, so they're not going through probate. So one is the cost. The other issue with a probate is the time that it takes. So when you have assets that are available and family members need to pay for funerals and need to pay for if there's family remaining that needs to be taken care of, a spouse, and there are ways of getting that through a probate, but it's, there's always that time lag of filing things and waiting for the process to go through and get signatures from judges and that sort of thing. So many people, for that reason, are wanting to avoid probate. A trust, on the other hand, can be a very useful tool, especially if you have a great deal of assets, you're trying to avoid probate, or you have properties that are in different states. Because if you own a property here in Florida and then you have one in North Carolina, you have your cabin in North Carolina, my dream, or you have other properties elsewhere, every state where you have a piece of real property, you're going to have to do an ancillary probate. That can get very expensive and time consuming and just difficult to go through. So people like the trust. The problem with the trust is you don't have the court sort of looking over the shoulder of the trustee and making sure that, in fact, assets are distributed as they are supposed to be distributed, and then you might end up with some sort of a trust litigation. But most people who have large estates are wanting to have that trust because you got privacy there. Probate is public, with the exception of the inventory, which is confidential, but everything else that you can get online and look today and get on the clerk's website and see what's going on in a particular probate. So people like the privacy that a trust offers.
Now, when you get a trust, of course, you have to have a lawyer draw up the trust. But one of the things that I see, I'm doing divorce cases now, that people establish a trust, but they don't call what we say fund the trust. They never put anything in the trust. Can you talk a little bit about that?
Yes, and I'm glad that you mentioned that. Many people think, I've got my trust, I've done my estate planning, I'm good to go. And one of the things that we really follow up with our clients is, okay, you've got the trust now, what real estate do you have? Let's go ahead and transfer that real estate into the trust, if that's what they're wanting to do. And sometimes there are reasons that they don't want to do that. So we actually will, if they're Florida properties, we will draft a quick claim deed and actually transfer that property into the trust. The same thing with financial assets. We recommend that, unless there's a good reason, and I'll mention some of those reasons, most financial assets you want to have a direct beneficiary, so that it doesn't go through trust, it doesn't have to go through probate. Upon your death, it goes directly to those people that you would like to have that money.
Easiest way to transfer money upon death.
Definitely. Now, and it happens automatically as operation of law. You don't have to get courts involved or anybody else involved. You just produce your death certificate to the financial institution, and that will happen. However, if you have a child that has issues with drugs or alcohol abuse, if you have a child who overspends and you want to protect those assets, you don't want them to just go to creditors. I mean, you have a child who has special needs and you don't want to affect their ability to collect state benefits. There are reasons why you might not want to give those directly to those individuals, but for the most part, unless you have certain circumstances, then you should do the direct beneficiary is the best route.
Now, I heard before that a trust is the way that you can control money from the grave. So just like you said, that if you have perhaps a child that has a drug or alcohol problem and you know that if you give them this chunk of money, they're just going to blow it.
Right.
That this way you can ration it out and say every year they will get X amount of dollars, and then the trustee would be responsible for that. So I just want to lightly touch on that. If somebody asks you to be the executor of their trust and you're all honored thinking, oh, they must think I'm so smart, it is a job. It's a big job. And especially after they pass, it can become a full-time job. You did mention, though, that there is kind of a guideline about what you can get paid as an executor of a trust.
Right. And, both as a personal representatives for a probating an estate can be paid. That's 3%. Most personal representatives, in my my experience with probate. They're family members. They don't ask to be paid. They just do the work, and the assets are distributed, and they don't ask for any extra money for that. But they can if they wanted to. And then the same thing with a trust. They can a trustee can charge 3%. And again, most of the time, unless it's a professional trustee, most family members aren't doing that. They're just doing it because their family member has asked them to do it.
Okay. Now, we're going to talk about the rest of the documents we need, but I just want to kind of take a little tangent here. Since we talked about a will and we talked about a trust, and we also talked about naming beneficiaries as ways to transfer assets, we lightly touched last week on a document called a Lady Bird Deed, and that is a way to transfer your homestead, correct?
It is. It's actually a life estate. And what a life estate deed does is it allows somebody to remain in the property during the course of his or her life, and then at the end of his or her life, that property, the remainder, and they call them the remainder men, sort of sexist, I guess, remainder person, and that's transferred upon the death of the person who has the life estate. There are different versions of that, and the Ladybird allows the person who has the life estate to have more control over the property, whereas some more traditional life estates, it's the remainder man who has a little bit more control in deciding if the property's sold. Even if at some point somebody who has any type of life estate, if at some point that person needs to move, say somebody had created a life estate and left the remainder to their children, hoping to stay in the property to the end of his or her life, but is unable to. That property can be sold, and the person who has a life estate would still get a portion. So you look at the charts to see what life expectancy is and what there's percentages depending upon the age, the life expectancy. A portion of that, whatever percentage that is, remains with the person who has the life estate, becomes their property, their asset, and then the remainder men get the other percentage. So, but it is a nice tool to use if you're not wanting to do a trust. But again, anytime you create any documents like that, whether it be some of the other documents we're going to be talking about or any of those like a life estate, you do have to be really careful in what type of a life estate you draft, and the power that in the case of a life estate, the power that the remainderman has. If it's your property and you're giving yourself a life estate, you want to make sure that midway through your life, somebody doesn't have the power to sell the house out from underneath you.
Wouldn't that
so you
be
have
great?
So you have to be really careful, and that's when it's worth the money to go in and talk to and have a consultation with a professional. Most people will say, "Oh my gosh," and professional, attorneys charge different rates for an hour consultation. It can be between $200, it can be $350. But if you're talking about your home and being able to stay in your home or not, that becomes a very small price to pay to make sure that you get the right legal advice.
Exactly. My big thing lately is you don't know what you don't know, and that's what can really hurt you. So it may seem like a lot of money up front, but it can save you a huge amount on the back end. Okay, let's move along then and talk about what is the next document, the basic document that everybody, regardless of income or assets, should have.
One thing I did want to mention, we talked about a will and a trust. One of the things that I do for a will, and I know many other attorneys do, is we attach a separate schedule to a will with some personal property items. So if you have a ring from your grandmother you want to leave to a particular person, a painting you want to leave to a particular person, you don't have to include that in your will. You can have that as an attachment, sign it like you would your will documents with 2 witnesses and a notary. But the nice thing about that is you can update it at any time without having to amend your will. So it's
great.
Inexpensive to do, to just take that other paper off and destroy it and add the most up-to-date, because we sell things or we acquire new things that
or
we
people
might
make
want.
us angry and we no longer want them to have that thing.
We change our yes, we've cut you out.
Yeah.
You
We
didn't visit
like
us
that
this summer.
behavior. Yeah, exactly.
So I did want to mention that. One of the things that I stress when I have consultations with clients on estate planning is, yes, the assets are important, and we want to make sure that, we've worked hard for these assets, so we want to make sure that we, the people that we want to get them. But we also need to focus on how we as individuals want to be treated at the end of our life. So if we are incapacitated, say we have Alzheimer's, something like that, we have some sort of end-stage condition where we're not able to think properly, we want to know that there's somebody there who's making decisions on our behalf regarding our care that we trust. So a healthcare surrogate is really important. And again, other states call it different things, but some states I think call it a power of attorney for health care. But in Florida, we call it a healthcare surrogate. And that person makes decisions on your behalf, and they should be making those decisions about your health based on what you would want. So it's really important to choose somebody that will make the hard decisions and make those decisions that you would want to be made. And one of the instruments that sort of can guide that healthcare surrogate is a living will. And a living will lays out those types of things that either you would or would not want. For example, maybe you don't want to be hooked up to a ventilator. Maybe you don't want kidney dialysis. Some people go so far they don't want food and water if they're in an end-stage condition. So it really is, there's some general language, but you can make it as specific as you want. So that helps the healthcare surrogate, guides the healthcare surrogate. We also do a HIPAA release because the HIPAA laws, doctors and medical facilities really can't share information with somebody who doesn't have the authority to get that information.
So do you need the HIPAA release along with the healthcare surrogate, or would the healthcare surrogate stand alone to give you that HIPAA
I
information?
do both.
Okay.
Just for, I'm very cautious. I want that extra insurance. Some doctors are real sticklers regarding that, the HIPAA laws. Others are a little bit more flexible and understand somebody as a healthcare surrogate. They can't make decisions if they don't have the medical information. But we make sure that we include that just to be on the safe side. One thing to point out, though, is a healthcare surrogate is only to make decisions while you are unable to. So if, God forbid, you get into a car accident and you're in a coma for 2 or 3 days, your healthcare surrogate's going to be making decisions about your health. As soon as you come out of that coma and you're able to think clearly, your healthcare surrogate no longer has that power. You are going to make those decisions. So I think that's important to remind people of.
The other thing that I think is important is a lot of people feel they don't need that healthcare surrogate if they're the spouse or they're the parent. Can you talk about that? I mean, do you automatically have rights to be a healthcare surrogate if you're the spouse, or do you need that piece of paper?
Well, if you go into a hospital and your spouse is sick, people are, the doctors are going to listen to your spouse.
Okay.
And 9 times out of 10, when we do the estate planning, a spouse will choose their spouse. But that's not always the case. There are times when a spouse will choose a child or choose another person because they don't feel that their spouse would be able to, not that they don't trust the spouse, but they don't feel that the spouse would, under those conditions, be able to think clearly, would be so upset about what's going on that they wouldn't necessarily make the choices that that person would want to have made. So you don't have to choose your spouse, but if you don't have a healthcare surrogate, then that's what they're going to do, is the doctors, medical facilities are going to look at your spouse. What we find, though, is you have situations where people are unmarried. And that's when you really have a problem, because
There's
you have
a
no
lot of
legal
that.
rights if you're not married. So, it's you might get lucky and, go to the hospital and they're going to listen to the significant other, or they may say, who are you? You have no legal rights. You can't make those decisions. Where is the rest of the family? Where's the parent or the siblings? So especially when you're not married, these become very important.
Really quickly, I want to talk about, what about parents of adult children? Do they have rights or no?
Really not. If the parent is married, the spouse is the one that makes those decisions, and that can be heartbreaking.
Yeah.
But that is pretty much how it is. I mean, and same thing with a probate. The spouse is going to come first over adult children unless there's been some estate planning. And especially when you have situations where you have step families and you have additional children, and that's when the estate planning really becomes important, because who gets to make those decisions? How are assets going to be divided? it becomes really important. The one other thing that I did want to mention, durable power of attorney is for making financial decisions when you're unable to, but you can also use that if you just get to the point where you don't want to take care of your things. So it's not just for if you're incapacitated. It could be that you just reached a point in your life that you don't want to handle financial situations. And then one last thing, a pre-need guardian. You can choose in advance who you'd like to have as a guardian if you're unable, if you do end up needing a guardian. So I suggest you do a pre-need guardian.
How is a guardian? We only have a couple of minutes. This is driving me crazy. I have so much to ask you. But how is a guardian different than a power of attorney?
A guardian, depending upon, the court appoints a guardian, and it depends upon whether you need a full guardianship or just a limited guardianship. They can just take care of financial things, can make all sorts of decisions. I mean, that you have to be declared incapacitated, so you're not able to make decisions. So that's a very long court process, and it's only in certain situations where the person can no longer make decisions, and usually that happens because of some sort of emergency type of situation. Something's happening where somebody's unsafe, and so somebody else steps in and says, okay, we need to have our guardianship set up here.
And if you don't have that pre-appointed guardian, the courts can appoint a third party who you don't even know, and they're making decisions on your life, and they don't even know you. So that's
now the courts are going
important
to first try and appoint somebody within the family. They'll look first there, but there's lots of professional guardians and public guardians that are handling guardianships because there's not a family member.
Okay. Well, Wendy, we've only got 3 minutes left. So is there anything that you just are dying to impart some wisdom on our listeners right now? You got the floor.
Well, it doesn't matter whether you are 19 years old or you are 85, 95, 100. You need to speak with somebody about some estate planning. I'm doing a probate now on a 21-year-old. Died unexpectedly. So, I mean, this is very sad, and he had children. So, I mean, that's something that we all need to be thinking about, especially if you have children. So I suggest you call an attorney and get that estate planning going.
Because we don't know when our time is up. And it's not just a service, as we found out, for those we leave behind, but it's really the quality of life that we're going to have toward the end. So I hope that this show is just inspiring everyone to come see you and talk about how they can get their affairs in order. I want to just throw in real quick, I mentioned last week that my mom passed, and so I'm dealing with that right now. But just the stress of the grief when you're dealing with somebody who's left you, whether it was expected or not, is hard enough. But then when you throw on all these legal ramifications that if you were to, or I thought that we had things pretty much set, but I realize now we could have perhaps received more guidance on doing things. And again, the fact that every state is different. But Wendy, if our listeners do want to get a hold of you, can you tell us how we can?
Yes. You can look at my website, maralawpa.com, or call us at 386-672-8081, and we'd love to take care of you.
And you're located in the Boulevard, is that right, at 555 West Granada Boulevard?
Suite B2. So thank you for having me. I appreciate it.
I really appreciate your coming on, Wendy. I wish we had an hour. I've got 5 more pages of notes to discuss. But I want to thank everyone for listening this morning. I hope you did get something out of our show, and I hope that we're inspiring you to get your affairs in order so that you don't leave a mess for other people, but also so that at the end of your life, your quality is what you want it to be. Thank you again for joining us. My name is Lori Taylor. I'm an investment advisor at Anchor Certified Planners Group, and you can reach me at 386-615-7526. Have a wonderful week.
Discussions in the previous show should not be construed as specific recommendations or investment advice. Always consult with your investment professional before making important investment decisions. Bill Greggett is a registered principal. Securities and investment advisory services are offered through NPC of America, a registered investment advisor. Anchor Certified Planners Group, Inc. and NPCOA are separate and unrelated companies.
Daytona's morning news station is on FM 93.5 and AM 1150 WNDB, Daytona Beach.